Right, so let's get started, guys. We're going to dive straight in to this panel, and I'm going to go to Neil first. And Neil, a bit of a broad question, but what are your thoughts on the Renters' Rights Bill and the impact that it is going to have on our industry?
Well, look, that could be probably a whole panel just on itself. David's talked about it before, but the extra powers that have been given to local authorities to prosecute, that's the first thing that comes to an effect. But there's also a real change into them no longer having a responsibility to enforce, but to have a duty. And it seems like a small change, that word, but actually in the local authority, in the government context, that puts a lot more pressure on them to actually deal with this. So if we've got agents or landlords that you've seen that are not doing the things that you're doing and operating correctly and have thought, we've got away with it, we'll keep getting away with it, this change they may find will hugely affect them. And that doesn't need any implementation. The powers to enter a property business and claim those records, they will have from the 27th. And that doesn't need you to make any change, but you need to be aware that if any information is required from you now by a local authority, you will have a duty to provide that, or without any warrant or even a belief that a crime has taken place, they can enter your business and walk away with that information, even in its digital format. So it's quite draconian, the powers that they have, and they automatically come in. So that's the first thing we just need to be ready for and make sure that we've got all our T's crossed, all our I's dotted and ready that should that happen, it's not going to affect our business. But the rest will come, and I think David's talked towards the dates, but we need to make sure that we're ready for that first date.
So we could actually be welcoming the local authorities into our offices without notice, requesting all of the information of our property files. Wonderful. Okay, so David, I'm going to ask you the same question from your perspective, leading on from Neil.
Yeah, I mean, of course things will change, but change is a given. In some sense, I don't think things will change, and things will always change more slowly than we expect. People will be on the front, people will be on the back, there'll be people in the middle, but local authorities have new powers, but in practice it takes them months to get their heads around what those powers are, to pass internal resolutions and set up processes. So things will change, but the reality is I think most agents, from what I can see, are trying to keep their business models very static at the moment. They're not going to change them that much. Most landlords are obviously a bit clueless because they tend to be. Except for NRLA members. Obviously, landlords who are not NRLA members, which is a lot of them, are a little bit clueless. And it will take time for all of this information to filter through. And with all of these changes, you get a lot of fits and starts. You get a lot of people who believe X, but actually the truth is Y. Everyone might well indeed believe Y for a while until the courts tell us it's Z. So the reality is that things will change, but almost certainly not quite as fast as we fear.
And Sophie, from a practitioner point of view, what are your thoughts on the same question? How do you feel? Because we've been talking about this for a long time, and for David, calmly, legal solicitor, sits there, I think it will all be fine. And we're like, in the background as letting agents. That's the reality, isn't it, guys? We know it's coming, and for us it's going to be a huge change. So from a practicality point of view.
Yeah, I mean, look, we've known this is coming in some form or another since 2019, as David said earlier. So this isn't our first conversation on it. This isn't a shock. Any good agent should have been preparing for this for a period of time, in whatever form it be. I know a lot of people are waiting for the actual wording and more technical information, and obviously everyone who's read the guidance will know that that's not overly helpful either. So we're kind of having to change our internal processes. For us, it's a big change because our internal processes have to change. Not necessarily things that people see from the outside, but what we have to deal with on the inside, which is all of our processes, how we deal with a let has to change in some form or another from the very moment we put it on the market to the moment the tenant vacates. It touches all parts of our process. So for us, it is a big change because we have to make sure those processes are in place. I know when the Act comes in, or is the implementation date, is that there is some grey areas, because, the government love a bit of grey. It's their favourite colour. And we're waiting, and no one wants to be the test case, right? So we want to try and do everything we can to get us prepped for it as soon as we can. So, things are going to change for us, but it's mostly internal. I mean, we need to reassure our clients is our biggest job and make sure we're training our teams well so they know what they're doing, they know how they're handling, and they know what they're saying to our clients. It's all well and good business owners knowing what to say, but your team need to be saying the right thing. So that's where we're looking at for the next few months, definitely.
Absolutely. So for us as agents, our whole processes internally are going to change. But I think you mentioned something really key there that I'd like to bring Valerie in on now, is about how are we, or how should we as agents be communicating the changes to the people that matter most, the clients, the landlords, the tenants. It's going to affect them directly. How should we do, Valerie?
Yeah, so I think you've got two sets of clients, because when we have the implementation date, in a way, it's going to be much easier with a brand new landlord and a brand new tenant on an assured periodic. But you have a massive portfolio, all of us have portfolios, where the existing landlords and tenants are going to need really clear communication. And yesterday I was talking to somebody who deals with Consumer Rights Acts, etc., and consumer law, and she said, unless everyone keeps everything simple, customers can't grasp it. So just think about your customer database. Know your landlord, know the methodology that suits that landlord and tenant when you need to communicate with them about the changes and how it's going to convert them. Because as you know, a minute past midnight on the implementation date, your assured short-hold tenancy will automatically convert to an assured periodic. Now, you won't have to repaper, so what I mean by that, you don't have to issue a new tenancy agreement, but there will be the government pamphlet or letter. We don't quite know what it's going to look like yet, but there will be something that we have to provide the customer with. But that's not going to be enough. Those customers are going to need you, feel like that, we're going to need you, to be able to communicate in such a way that they understand. So imagine you're a tenant and a landlord on a fixed-term tenancy. Now, I was at a landlord show recently, and I was talking to a landlord, and 3 times I mentioned very carefully, oh, well, don't worry about your tenancy, because when you get to implementation date, your fixed term will fall away. And he just couldn't comprehend that a fixed term tenancy agreement that he's agreed with his tenant will be gone. So you've got to find ways of explaining that type of change, and to tenants that you've got to give 2 months' notice, there's no end date. And, you know, abolishing a Section 21, I can't see because the lights are very bright, but if there's anyone of my vintage, you'll remember it was a relief when Section 21s came in, because prior to that, the legislation was indeed very complicated and you missed key dates. But this sector, the sector we all work in, is very resilient, and that's why people like you are coming to events like this to make sure you're as equipped as you possibly can be to manage your landlord database. So education, communication to your customers in simple, easy to understand ways. You can have webinars for your landlords, you can have little evenings for your landlords, just to reassure them what those changes mean, that their investment is still going to be safe, they are going to be able to get their property back, it's just going to look different. And it's about explaining your skill in explaining what that adaptation looks like and making sure your teams feel expert enough and confident enough to discuss these changes.
Absolutely, and a brilliant point that you've raised there is about communicating to our tenants, because we all know that the landlords are our clients, but there are changes happening for the tenants, because we have multiple tenants that still want fixed term. You have to educate them that that no longer is an option, and also that it doesn't mean that your landlord wants to evict you. So I think that's a really good point, and Neil, you wanted to say something else.
I just want to say that don't miss out on this opportunity either. This is the opportunity for us to put our value proposition forward. This change has never made it more important for a tenant or a landlord to be using an agent's services.
Wonderful.
You're going to have to communicate them. Make sure everybody in your business understands your value proposition, and don't waste that communication. The government is going to make you communicate this out and make it a requirement. But this is the point where you reinforce why they're using you, why your expertise are important, the protections that they get by using your services. And that will then happen. Landlords know other landlords. They talk and operate in those circles. And the same people who couldn't comprehend that Valerie was speaking to will go out and speak to landlords. How are you coping with it? If they're able to communicate your value proposition to other landlords, then that will be your sales method. You've got a great opportunity to grab this. Don't just feel it's a tick box exercise to make sure the pamphlet is able to be communicated by our staff.
Absolutely, and I think that's a really good point, and I'm going to come to Ben next, because I actually think it's quite shocking for people like us that there are actually still letting agents out there that are still now, right to the very last month in October, I employed a staff member, and within the agency that she worked for, they are not communicating about renters' rights. They're not talking about it internally. They are not talking about it to their clients. It turned out they're actually still operating from Excel spreadsheets. And I just was bemused that this is a local agent in our area, that was still the case. But the reason I want to come to you, Ben, is from a landlord's perspective, and following on from what Neil said there, are landlords aware what's going on? Do they know what's coming? And do you think actually for those DIY landlords now is the time to start considering your options of using an agent? Because this is a big change.
Well, on behalf of the simpleton landlord community,
we love you, Ben. We love you.
Simpleton in chief is my job title. No, these are going to be some of the biggest changes that we've seen in a generation, and I think that what we have seen is actually an element of fatigue. And whittering on about Section 21 this and fixed terms that. I think landlords will come to terms with it fairly quickly. Valerie is right. The sector is resilient, and successive governments have kicked landlords from pillar to post, and the majority of them are still here. So I think it's well within landlords' gift to be able to adapt. I do think it's a huge opportunity for you guys. The one thing that's certain out of this is that we will make a shitload of money. And you will need to be prepared to be able to monetize that in a way that brings your clients along with you for the journey. This is one thing that the sector is very good at doing. And I think if we're talking to an informed audience, this is about preparedness now. This is about making the reforms a success. And we've been very, very clear that the sector needs time to be able to adjust. I won't bore you with the detail, but I don't think that is quite enough time. But that's what you're going to be working to. So I do think that after an element of fatigue, Dawn, that landlords are really going to get to grips with this, and it's incumbent on all of us to make sure that if they do want to stay in the sector, if they are happy to deal with these reforms, and there's no reason why they shouldn't, that we're there to support them. And I think that's exactly what's going to happen.
And just a follow-on question from that, Ben, what would you say, and we're not here to criticise landlords, they're our clients, but what would you say, in a way, how much have they educated themselves, the self-managing landlords, in preparation for this?
Do you know what, if we look at the sector as a whole, I think that we have a massive downer on just how good the private rented sector is. I sat at a select committee, watch it back, because I got very irritated last week, where
that's never happened before.
I was saying to Val, I'm in a perpetual state of irritation at the moment, Can't even watch Strictly without throwing something at the TV. But anyway, where was I going with that? I can't remember where I was going with that.
I was going to do a dance.
Yeah, so the point I was raising was that the argument is that the private rented sector is somehow sat on its hands. Now, I do think there are elements of the private rented sector that can be better. And, the fact that we're still hearing from landlords and agents who, frankly haven't got a clue what's going on is a problem. And that's why government regulate. But if you look at the overall statistics, Increase of A to C in terms of EPCs, massively up. Satisfaction, massively up. Lack of Category 1 hazards, but 91% of properties without a Category 1 hazard. This is a sector that's being asked to do very many things that it was never intended to. So my message to government is continually, be careful what you wish for, because these investors have got a choice. They do have a choice, and I don't buy the argument that Section 21 is actually going to massively change the homelessness outlook. What will change homelessness is keeping landlords in the sector. That's the biggest cause of homelessness, landlords selling. And politicians don't like it when you point it out because it doesn't fit their agenda. But that's the truth. In 2 years' time, Section 8 will be the leading cause of homelessness. So we need to get away from this sort of nonsense. And you guys have got a huge part to play in all of that, as we all do.
It will change the homelessness statistics. The thing the government has carefully ignored, of course, is Section 21 covers up lots of sins. It covers up landlord sins, but it also covers up tenant sins. And if every eviction now has a reason, then every tenant who presents to a local authority as potentially homeless is going to be asked, why? Can I see your Section 8 notice? Oh, you haven't paid your rent. Terribly sorry.
They won't help.
You don't fall within our housing parameters. Off you go. And in fact, ironically, the amount of street homelessness might end up going up, not down. And this is the thing that really frightens me about this, because politicians who think they've solved a problem and then discover they haven't tend to react in a knee-jerk way. And Scotland's rent control efforts are a good example of this. And so it becomes quite frightening. And of course, the further in you get into a government that's already having difficulty managing a message, that then wants to head in another year's time, it's going to have to start thinking about the electoral cycle. What are they going to say next? What's your next magic solution? The problem with great magic solutions is if they don't work, then you've got to come up with another one. And there's only a certain amount of magic available in the room. It can only go so far.
If I just add in there, one of the unintended consequences will be that tenants, we might start to see an increase with tenants with CCJs, because the Section 8 grounds will have a reason why you've had a possession notice, whereas the Section 21s just go on, don't they? And we use Section 21s. I was just saying to Ben earlier on, I was talking to a letting agent with a tricky antisocial behaviour issue, and she was trying to pursue an antisocial behaviour possession. And I just said, well, why don't you just for now use the Section 21, because that's a bit as straightforward as you can be. So the new grounds moving forward will be very specific. We're not experienced yet in how we deal with antisocial behaviour and things like that. So my concern is this whole affordability criteria is actually going to get quite acute as we move through the gears when we start to get statistical analysis of what type of grounds we use for possession notice, which we don't really have so much as the reasons under a Section 21, because it's kind of a Section 21 is one size fits everything. And I really don't like this phrase that it's a no-fault eviction and I'm being evicted of that. But if you think about it with a Section 21, when that was actually introduced, that Housing Act, it just made things easier because you weren't following direct tram lines for an evidence-based possession notice, which is what we are all going to have to follow. And David Smith, I absolutely agree with David, we are going to have to get better at utilising the discretionary grounds, which we don't at the moment because we rely on a Section 21. So I think it will take an unintended consequence. The output for this is the affordability for tenants moving forward.
And those that are on the margins too, because I'm very clear. I'm not going to take a punt on people. I'm not going to wait a bloody year to get possession of my property back. I'm certainly not going to wait 4 months to be able to have the privilege of waiting a year in terms of rent arrears. So I think your clients are going to be rightly pickier. And they're going to need you to be far more forensic, because if the shit does hit the fan, they're going to be 18 months down in terms of rent, and that's a straightforward financial decision of viability. Nobody can go really 18 months without being paid. Why should a small landlord? And I think the environment that we are in, you've got a massive role to guide people through that and make sure that your policies and procedures are absolutely A1, but for our political masters, this is going to, I don't even think it's an unintended consequence. I think it's a known risk. I think they know exactly what they're doing. And those that are from overseas have got dodgy credit, the offer to pay 6 months rent up front. I ain't interested. And I don't think your clients will be. Government will be able to house them. There's so many social homes that are being built. So, with no carpets, go and choose one of them.
Oh, Ben, you do bring some humour to this panel. We love you. Talking about notices, one of the things, we've got David here, so I think one of the burning questions that our landlords will have is, of course, what does the courts look like and what does the waiting time look like when Section 21 goes? Because currently Section 21 can be heard without the need to attend through accelerated possession. What does that look like, David? I know you don't have you can't see into the future.
I'm trying to think of a good way to say bin fire here.
He's trying to think of a good word to say.
I'm trying not to say bin fire, but the correct phrase is bin fire. So I haven't actually seen, but Neil pointed out that the stats for possession for the last quarter have dropped.
Wow.
But the 2 previous quarters show a drop in possession as against the same time last year, but possession taking longer. And that's being driven by landlords in London, who are more apt to use traditional proceedings, are more apt to use a solicitor. And actually, oddly enough, although the number of possession actions started is dropping, the number of possession orders is climbing. So what's happening is people are tending to use possession claims more accurately, get them right more, probably because they're hiring people, because they're in London, and so the value is greater, so it's worth it. But what that's kind of telling you is that landlords in some areas are starting to move out of the sector, and the Renters' Rights Act drumbeat, as it were, has been heard. But what's also gone up, of course, is the amount of time you have to wait. And what the government has done very cleverly now is it doesn't talk about averages anymore. It talks about the median and the mean. So you can get your maths head on here. But the median's gone up by 2 weeks. But what's really startling is the mean is way higher than the median. So what that's telling you is that there are some possession claims that take a really long time to start through. And the problem with all of this is you get rid of all the paper-based stuff. Now, the government's view is that the 20,000 Section 21 accelerated claims will just go. Because landlords just won't do that anymore. Because, they were only repossessing anyway to put the rent up and just other evil things. And Ben will be able to talk to this better than me, but there's lots of stats, and NRLA has generated lots of stats that suggest that around 3/4 of Section 21 notices were for cause. So if you assume that's right for a minute, 15,000 of those 20,000 cases are presumably just going to reappear as Section 8 cases with the vast number of judges we have available. And again, every district judge competition for the last year and a half hasn't met quota because they can't find enough good qualified people who want to be judges. So people are applying, but then they're being binned off for being no good. And then, of course, you've also got to have court space, which we're a bit short of.
I mean, isn't it just mad, right, that we follow this nonsense, follow this nonsense hook, line and sinker, and are somehow, now afraid to call out people that don't behave properly in their rental properties, that trash places, that rack up rent arrears, and we think, oh, poor little sausages, those nasty landlords trying to use a legitimate ground to get possession of their property. I mean, we've come to some sort of fanciful, mental world where everybody believes this nonsense. And, it's certainly not for the want of trying, but articulating that is absolutely not the case, I'm afraid, is falling on deaf ears, but it will come full circle.
What makes it worse is the government's actually throwing more money at justice, but none of it's going into civil justice. So it's all going into criminal justice, and it's not working. There was a case recently where someone was up for a Crown Court trial, and the date they were given, first available trial date, is 2029.
Wow.
And they're on remand, so they're in prison, potentially completely innocent, but in prison till 2029. There are 80,000 criminal trials now pending without finalised trial dates. So the problem for the government is, even though the vast majority of people, 3/4 of the population will encounter the civil courts, whereas less than 1/10 will deal with the criminal courts in their lives, if you're going to spend money, you always spend it on criminal justice, because what's more interesting in the newspapers? Yes, we've cut down criminal trial dates. Oh, but yeah, all that civil stuff's going wrong. But the newspapers obviously will report these ridiculous statistics for criminal trials first. And so the government's diverting a lot of money into justice, but into completely the wrong part, from our perspective at least. And it's not moving forward.
Thank you. Very briefly, Neil, because I've got two more questions I want to ask you guys.
I do just want to reference back, because David said it when he was on the stage. He said, people don't come and tell him the good things. I think we do have to remember that for the government, they don't hear about those good tenants. They don't go to their constituency meetings. The lens that they look through our industry is very jaded. And that's why some of the things that hit our industry, we have to find ways to navigate. We have to be that message as to why these have happened, because they are coming in from their constituency, from being bombarded by tenants coming in. And yes, there are literally millions of great landlords out there, but that minority is all they see. And that's what they, unfortunately, are then judging the changes that they make.
Well, good news stories don't sell newspapers.
Absolutely. So, guys, we're limited on time. I want to go back to a couple of practical questions for our agents here, because, again, these are the questions that landlords are asking us. So, Valerie, I'm going to come to you. So we've talked about notices. We've talked about the loss of Section 21. Can you just briefly talk to us about those that are already in Section 21 proceedings and what will happen with them come the wonderful implementation date of the 1st of May?
So you will be having landlords that still instruct you to issue a Section 21, and you can continue to do this. I would like to think that we've got most of these things out of the way as we get closer now to we know the implementation date. So work it backwards. In a way, it's useful to have that implementation date. And they will be in the system till the expiry date of the Section 21, or we need an issue date at court. So you are going to have to keep an eye on them and make sure that you don't lose them in the system. We were talking about this earlier on, because I mentioned that there's going to be a leaflet or a pamphlet that we have to provide to tenants to let them know they're an assured tenant now. They're no longer on an AST. But these tenants won't be an assured tenant because they're actually in the Section 21 process. So my top tip is, if you have a department that deals with your rent arrears or credit control, you need to be making sure they understand this message, because I know you're all constructed very differently how you run your agencies, but to make sure you have that information. But any of you that have partnered with a rental insurance provider, a rental guarantee provider, speak to them as well, because they will be applying panel law firms, etc., for your Section 21. So just have that as an action point as you get closer to the 1st of May.
Can I just very quickly add, I think you guys have got a huge responsibility to manage emotional landlords, of which I am one, right?
Who's happy they don't manage Ben's properties, eh?
So what we don't want to happen is landlords get wind of this date and then think, bugger me, I need to use it or lose it. That's exactly what we don't want to happen. I think you've got a big role to play there. Of course, there is a use it or lose it element, but just because you've got somebody that was on the cusp of affordability 300 years ago is not a reason to evict them now. So, I think we've got to absolutely play that down. But there will be some key milestones in terms of this use it or lose it date. You'll have a 3-month window, and then I think you've got to commence proceedings by July. So do get to grips with these dates. But I think managing your emotional landlords is absolutely something you've got to do.
Absolutely. And guys, that brings us to the end of our panel. But before we close, 30 seconds, guys. Just your final words of wisdom for the agents. What would you say to them with 30 seconds?
These guys will talk about worst case scenarios about the courts thing. I think our job as agents is not to get it to that stage. We are going to have to do a lot more education, a lot more negotiation. We're going to need to make sure we're protecting our clients every way, whether that be right at the start with the vetting, whether that goes right through during the tenancy. We're going to have to be really hot on lots of things to just not let it get to the catastrophe stage of waiting for courts, etc., etc. So I would say you need to be educating your team, educating your landlords, making sure you're getting the right information, because there's a lot of misinformation. Please do not ask ChatGPT for what the law says.
Please do not.
Because it is incorrect. it's behind. So, you know, make sure you're getting the right information. Don't read everything online. Make sure you go to the right sources. Education is going to be key.
Thank you very much, Sophie. Neil?
Mine is, as part of your preparation, speak to your tech providers. Most tech providers have been aware of this for a while and already building things. I know we've done stuff behind that can be released in configuration and ready so that it can protect you from the rental bidding changes or when you're able to use the different grounds for Section 8. We're actually building that in so that although your staff train them, make sure they're aware, we have a secondary catch so that if anybody's going through this transition, actually the system will be able to assist them and keep them compliant. Lots of tech are doing this. Make sure you have that conversation, because if you don't, you won't necessarily know what they're doing to help you already.
And one of my apologies, guys, because that was actually one of my questions for you, Neil, but as you can see, we're out of time. But guys, Neil is around. Please, if he can help you at all, go and talk to him about how tech can help us in the new world that we're going into. Valerie?
Yeah, if there's one job role that I think is going to have a massive adaptation, it's your negotiator, or whoever is the frontline person that deals with your applicant registration for tenant inquiries. Because moving forward, you don't want the negotiator to inadvertently get caught up in the anti-discrimination laws that are coming in. I think generally negotiators, letting agents like to be helpful. They want to house people. We're just going to have to be really careful about its affordability and make sure that you understand who your tenant referencing provider is, how they are allocating the reference criteria so that you are confident that you can explain this. Actually, under the Tenant Fee Act, we are supposed to, in any event, be explaining how referencing criteria works in case you've got a CCJ and that's associated with your holding deposit. But it's really important now about the affordability criteria so that negs don't get caught up in the anti-discrimination for people in receipt of universal credit or actually families. And that links into the point that Neil's just said. It also links into the bidding war so that you get the rents right as well.
Thank you very much, Valerie. Ben?
Briefly, preparedness, cool heads, shit-hot comms, don't stop drinking.
Yay! What a summary! And David, to finalise.
Yeah, I would endorse what a number of people have said in different ways. Communication is critical in all levels of your business with everyone you're dealing with, and much more nuance is going to be necessary. There's, historically, and even now, people have very didactic, this is the answer to this problem. There'll be a lot more situations where a more nuanced approach is necessary.
Guys, you've been awesome. They could literally sit up here and talk about this all day, but that's not what we're here for. But guys, for this session, please give a round of applause to our expert panel.